Good afternoon, or good morning, Madam President, Your Honors, and to everybody in the courtroom. Starting with what we heard today from my friend, it doesn't happen often in this case, but I'd like to thank him for his submissions, because everything he said, literally this morning, showed why this case should go to trial, and that we have met the standard of substantial grounds for confirmation. What my friend did today, going through these incidents, trying to pick them apart, that sounded like a closing argument after a trial. The types of issue he raised today and yesterday, well, in this incident, the first witness says X, the second witness says Y. That's what gets sorted out at trial. The witness that supports our charge is enough for the confirmation of the charges. Another example, he talked about the police reports and that there has to be a presumption of regularity. You have to accept these as face value. Well, at trial, as we've stated in our brief, at trial, we will show, through witness testimony, that these these police reports were often falsified. In addition, we'd make the point that during this period, when my friend says, look at this police report, it says the victim had a gun. We say the gun was planted. That is what is for the judges at trial to sort out by hearing the witnesses. And we will also point out that during this period, when the reports came out, and Mr. Kaufman also talked about search warrants being issued, how could it be a crime if a search warrant is issued? That Mr. Duterte, as we made clear in our presentation, moved co-perpetrators from Davao to Manila and appointed them to high positions. So when he appoints the chief of police, and part of the chief of police's job is to kill thousands of people, it's not a surprise that the police reports don't reflect that. If they decide to murder Mr. Espinosa and Mr. Yap while they're held in jail, it's not surprised that that can be done when Mr. Duterte appoints the head of the Department of Justice. Similar, he talked about, again, I'll get to it, talked about neutralize, and how that is a neutral word and needs to be taken in context. I'll come to that a little bit later. But again, there's evidence in this case, some of which Mr. Jeremy went through in his presentation, that neutralize meant to kill. Whether he is correct, or whether we're able to prove it beyond reasonable doubt is another issue. Whether we're at substantial grounds is clear. We are. And I just say, again, responding to his argument about the documentation, that it's not unique to this case. In war crimes trials, crimes against humanity trials, where the very top leadership are the persons on trial, and when they're committing their crimes, they don't put it in writing often, let's go out and commit a crime. Mr. Kaufman will know this because we both worked together at the ICTY. During the trials for Srebrenica and the other Bosnian Serb army crimes, the VRS, every single order that turned out to be criminal, virtually every single order, had in the order from the General Mladic down the chain, respect the Geneva Conventions, treat prisoners of war properly, treat civilians properly in accord with the Geneva Conventions. That was in virtually every order, and it didn't mean anything. It was boilerplate as part of their cover-up. I'll move on to some of his points from yesterday now. He spoke at length in the beginning about Article 7.1 and are an alleged problem or inconsistency with the all-history case in our definition of the civilian population in this case. The law is very clear. All that Article 7.1 requires is that an attack is directed against any civilian population. That term, any civilian population in 7.1, is not limited to populations defined by nationality, ethnicity, or another distinguishing feature of that nature. It's a question of fact to be decided by the trial chamber. We have set this out, paragraphs 17 through 20 of our DCC. It is not particularly complicated. It is not blurry or ambiguous. We stated that alleged criminals in the Philippines are the civilian population, which are the object of the attack. That's a factual issue. So the position taken in the El History case, which is different, obviously completely, factually to this case, is irrelevant. Second, the issue in El History did not concern the definition of the civilian population. It was about the nexus requirement, under Article 7, and whether it is necessary for victims of the underlying acts or crimes against humanity themselves to be members of the population. It was a different issue completely. And we have defined the population in this case. That just reminds me of what he said today at one point. Oh, well, these victims weren't necessarily related to drugs or the war on drugs. Read our brief. Read the DCC. It makes it clear that it's criminals, including drug dealers, drug pushers, drug users. The incident I went through, incident 3, in my presentation on Monday, I made it clear the victims there in Davao were alleged thieves. That is why they were murdered by Mr. Duterte. Very quickly, he complained or spoke about well, no, I'm going to skip that, Your Honor. It's not important. Moving on, he also made yesterday multiple comments that were inaccurate about the common plan alleged in the case. First, he said there was no direct evidence that even 2 of the co-perpetrators met in person to discuss the plan, the common plan. Legally, there's no requirement that they do so. However, factually, what he stated was incorrect. We have brought evidence of such meetings, and they're in our pre-confirmation brief. I won't go through it, but if you look at paragraph 27 and the items cited in footnote 135 of that paragraph, it sets it out. I'll come back now to the meaning of the term neutralize in the context of this case. It's open to interpretation in the abstract, but my friend, in trying to persuade Your Honors to take the view that neutralize didn't mean anything nefarious, quoted statement from Chief Ronald Bato de la Rosa, co-perpetrator de la Rosa, that neutralize did not mean to kill. That was at T006, page 31, lines 2 to 11. So he's been criticizing the credibility of our witnesses. Cites the police chief to say, the police chief who signed CMC 16, to say that neutralize is a neutral term that shouldn't be taken as showing any criminal intent. But we set out in our brief multiple witnesses for the mayoral period and for the presidential period who will testify that to neutralize means to kill. That's again set out in the brief, paragraphs 6 and 24. I'll read out just one example. This is ERN PHL OTP 000-15390-R01 at 0011, lines 345 to 346. Question of this insider witness. Okay, and the words eliminate and neutralize, what do they mean? Witness's answer, kill. You have to kill, whether it is a legitimate operation or not a police operation. So all of the dancing around about the term neutralize doesn't rise to the level where we would not be meeting our standard for confirmation today. One more example, my friend talked about it today. This is incident 13, in which the murder victims were Mayor Espinosa and Raul Yap. As we showed on Tuesday, Mr. Duterte, I won't play the video again, identified Espinosa as involved in drugs and said that he should be shot on sight and tracked down like a dog. And Mr. Kaufman said, yes, but Mr. Espinosa surrendered, and then tried to portray the murder of Espinosa in a jail cell as legitimate self-defense. In a jail cell, there's a shootout. The telling point here, as we said on Tuesday, transcript 5, page 10, lines 9 to 10, in the PRRD list, it was brought up, I believe, in the presentation. These two victims of incident 13, they are noted as neutralized on the list, not on the day they are arrested, not on the day they go to jail. They're marked neutralized on the days they're killed. So they were neutralized at the time they were murdered, per Mr. Duterte's government at that time. As I said in my submissions on Monday, right from the beginning, we acknowledge throughout his speeches, Mr. Duterte and some of his co-perpetrators, I used the term allies on Monday, referred to shoot to kill and self-defense, and that they sprinkled in these references to due process and legality. The evidence shows, as I said, that was only to build a veneer of legality, to create an impression of legality, and to give his lawyers something to say when this day came. And that's exactly what has happened. Mr. Kaufman has gone through, repeated these when he can as some kind of mantra that supposedly exculpates his client. It does not. As I said, this is the lawyer Duterte trying to build in a defense in case he was ever held to account for his crimes. The facts can't be denied by these sprinklings. He ran a death squad in Davao that he created. He ran it for over 20 years before he became president. His promise was to kill thousands, and he did. So it doesn't matter how many times he tried to throw in a caveat. And again, as I said, this is not uncommon in crimes committed by powerful figures. They try to build in a defense. One point Mr. Kaufman made yesterday, again, showing why this case is ready to go to trial and should not be dismissed. He refers to witnesses providing what he says is exculpatory evidence. He misstated these witnesses by saying they were OTP witnesses. They're not. We're not relying on them, but their statements are disclosed. We found these witnesses and interviewed them through the process that he portrays as somehow corrupt or biased or I don't know what. They provided exculpatory information, and we disclosed it. And that is somehow meant to say that this case should not go to confirmation? I mean, these witnesses are interviewed under 55-2. They're as suspects. Is it really unusual that when you're interviewing somebody who was involved in the crimes, that they say, I didn't do it? Does that mean that this case should not go to trial? Again, we go to trial. He can call those witnesses. The trial judges will listen to his witnesses, listen to the OTP witnesses, and then decide if we've proven our case beyond reasonable doubt or not. I'll speed up a bit, Your Honors, because I don't want to go over my time. He made a small point I just have to respond to, making a call. Why aren't there more investigations? Why aren't crimes being investigated now in the Philippines? Well, his client prevented all that by withdrawing the Philippines from the Rome Statute when he thought he might be prosecuted, thereby ensuring that we would not have jurisdiction after a certain period. Another point. My friend is trying to kind of have it both ways on how Your Honors should treat Mr. Duterte's utterances, his speeches, his words. On day 1, T0004 at page 30, lines 18 to 19, my friend said, Duterte's word was his word and the people knew it, end quote. Yesterday, worried about his client's confessions, that's what they are, he said, quote, this is at T0006, page 7, lines 5 to 7, he said, quote, one cannot rely on anything coming out of Mr. Duterte's mouth. All right, that's good to know if he ever decides to testify, and for his representations on interim release, that you can't trust a word that comes out of his mouth. But beyond that, as I went through on Monday, 3 times under oath, Mr. Duterte said in committee hearings, I have a death squad. Is Mr. Kaufman saying that his client is a liar and a perjurer who has no problem lying under oath? Limited use statements. I won't go through all the, frankly, nonsense that we heard about limited use statements. What I want to make clear, he tried to create an impression, which is just not true. Not one witness has been granted immunity in this case. None. There is no such thing as virtual immunity, or whatever he called it. He said something similar today. It's standard practice to use these statements when interviewing suspects under 55-2 who have rights, and they do not grant immunity. It just means the statement can't be used against that particular witness. And if they lie during those statements to us, to the OTP, then the agreement is void and they can be prosecuted. And his suggestion somehow that we should not interview the direct killers, Mr. Duterte's killers at the bottom of the pyramid, they shouldn't be interviewed, that's clinically insane from a prosecution point of view. And of course, some of those persons will get limited use statements if their lawyers request them. And finally, we're here in this court to prosecute the most responsible, and the most responsible is his client, former President Duterte, not the people on the ground who committed the killings. They are responsible, but they are not the most responsible. And unlike his client, the ones who have come forward have shown remorse for what they have done. His client, contrary to everything he said in the last few days, the last 3.5 hours, repeatedly admitted committing the crimes we're here for, his killings of his own people, the Filipino people. We saw some of those in our presentations. I'm sorry, I missed one point. He said there was no linkage of the incidents to Mr. Duterte. He said, my friend, not one incident where the direct order came from Mr. Duterte for one of these incidents? Well, he should look at incident 1 of the ones we have charged. And I'm afraid I don't have my cite because I skipped around. But in that incident, the evidence shows that we have a witness who heard Mr. Duterte on the phone, who heard that the order came from Superman, his client's code name and nickname. Mr. Jeremy is helping me. It's at para 89 of our brief, Your Honors. So that was wrong. That is, I just wanted to reply. He said that several times. It's not true. Back to Mr. Duterte. He's proud of his killings. He wants to be remembered for them. Decades of murdering his own people, murdering the children of the Philippines. And he claims that he did it all for his country. He doesn't deny it. He says, as I said early on, it's a necessary evil. It's for the greater good. Doesn't matter how many kids I have to kill. I'll clean up the Philippines. Now, I want to play a clip, Your Honors, if we can do that, James. This is, you'll see the beginning. I played just a few seconds of it. I'm going to play more of it now, about 2.5 minutes.
Na ginawa ko man ang lahat sa panahon ko para may konting katahimikan at mapayapa ang buhay ng Pilipino. Ang problema nito, ewan ko kung ang tingin ng ako'y raw yung o ganito na lang. Ito ganito na lang. O sabi ko, assuming na totoo, totoo talaga yung naririnig ninyo. Bakit ko ginawa yan? Para sa sarili ko? Para sa pamilya ko? Para sa inyo at ang inyong mga anak sa ating bayan. Ang higain ko na lang sa inyo, total, kung ganito man talaga ang swerte ko sa buhay, okay lang, tatanggapin ko yan. Eh, wala tayong magawa.
Excuse me, Counsel, you have 5 minutes left.
Hulihin tayo kung ikulong tayo. Kaya lang, meantime, mag-contribute kayo, baski $5, $10, para paglabas ko sa prisuhan, paggawaan ninyo akong monumento katabi ni Rizal. Si Rizal may hawak na libro eh. Akin.
Okay, what do we see there? This is essentially Mr. Duterte's farewell speech. It was made on 9 March last year, 3 days before, as he says, he was apprehended. He was not going to surrender, apprehended and surrendered to The Hague. What did we see there? First, I won't repeat it, shows total, utter contempt for this court. Second, referring to, quote, his sin, end quote, he says, assuming that all the talk you hear is true. Assuming it's all true, why did I do that? What is the talk that's all true? It's obvious. After he says that, he says, problem is, they think I'm the one who, and the crowd cheers. Again, he doesn't say it out loud because he knows he's on video. He doesn't want the words there. Assuming I'm the one who killed all these people. So he makes a little motion. Crowd goes wild, and he smiles because he likes that after he's made that statement. What innocent person has ever said, assuming I committed all these murders, it was for a really good reason? That's what they would like you to believe, that he doesn't mean it. And he says he did it not for himself, not for his family, but for the Filipino people, and it's obvious what he's talking about. He's talking about the murders. Again, the ends justify the means. Again, for him, the murders are a necessary evil for the greater good, as we heard right at the beginning of his career when he's teaching police officers to plant evidence. The end of that video, what does he ask for? He says, I might go to jail, what can we do? But when I get out, contribute money so there can be a monument erected of him when he's released from jail. And he describes what he wants that monument to be to himself, former President Duterte. A statue, not holding a book like the national hero Jose Rizal, but holding a gun. 3 days before his transfer to The Hague, this old man, you could see it still up there. What does he want to be remembered as? The man with the gun. And he's just taken credit for killing his own people. It's time for him to take responsibility for these crimes he brags about and glories in. Can we go to the next one quickly? I think I got about 3 minutes. James. This is tab 146.2. It's a quote from a speech on August 16th, 2017. What did he say? Quote, I know I will have my own downfall. I cannot be president forever. I know that they will demand to answer for all this dead. End quote. And he was right when he spoke those words. He must answer for the dead. The victims demand it, justice demands it, and for purposes of confirmation, the evidence demands it. We have proven it to the level for this to be bound over for trial. We ask you to do that, Your Honors. Thank you.
Merci beaucoup, Monsieur
Thank you very much, Mr. Nichols.